have a decision by the end of the day, but we will see how it goes.
Can I just address that, Your Honor? I mean, and again, it's totally up to you. I'm sorry to interrupt.
Go ahead.
Interrupt, but you know, we've thrown a lot at you. The city can use ORCP 79 to issue a temporary restraining order if you don't decide by Monday. But if you decide by Monday, we don't have to worry about that.
There will be a decision by Monday. I'm just saying I've not made the decision yet, and I will take this under advisement. So none of my questions are indicating any way I'm leaning or thinking, because I need to do some more research. But the plaintiffs have brought up, if I do grant an injunction, they've asked for the bond to be waived. I didn't see that being addressed by the city.
The city wouldn't have any objection to that if that was your choice.
Okay, we have half an hour. I will allow closing remarks at this time.
I won't take my 15-minute share of it, other than to say, I've lived in Portland for 27 years, and I do think, in addition to this humanitarian crisis, there's been a lot of nastiness about who's to blame, et cetera. And my hope is that, and I'm somewhat optimistic based on my interactions with city attorney's office, that that something can be worked out in this case, because this case isn't going to solve any of the big problems. I mean, there's a heaviness that I'm feeling around this, and I think everyone probably feels it, which is, we're not litigating for more affordable housing. We're not litigating for more shelter space. We're litigating about whether or not people can get under a blanket. People who have no access to affordable housing. The city estimates 23,000 housing units short of what we need to house low-income people. That means that even if we're right about the 10,000 people, that means there's a lot of people couch surfing, doubled up. I mean, it's not just the people that are living outside. And so, so I say that only because I want the door to be open as we move forward in this litigation to come up with something that doesn't just result in somebody winning and somebody losing, an endless litigation, because win, lose, or draw, I've done enough of these cases to know it doesn't matter that much to people living outside. The reality, the status quo is bad for my clients. And the issue before the court is, how much worse could it get if this ordinance is enforced? And unfortunately, it could get a lot worse. So it matters, but people are engaged in their daily life, and so it's not as though anyone will be celebrating if this ordinance is struck down, and I doubt that anyone in the city attorney's office is going to be celebrating if it isn't struck down at the end of the litigation. And so I just wanted to say that for perspective. But today, we don't know what evidence is going to come forward about this. And we don't know what kind of enforcement protocols could be put in place. And we don't know, what police protocols and various enforcement protocols, could be put in place. But this ordinance as drafted is objectively unreasonable based on the evidence that the court has in front of it right now. And the harm of it being enforced is very real. And again, the declarants who work with survivors of violence, LGBTQ people who are unhoused, James Duncan, his situation, it's not the $100 fine that's going to cause the most irreparable harm. It's trying to avoid going to jail and putting yourself in harm's way. And I'm not saying the city intended that. Again, it has to do with that disconnect between whether something makes logical sense when you are warm and dry and have access to high-speed internet, and you're researching these things. That list of place restrictions could not be more unreasonable in terms of people living outside, and the fact that the city hasn't provided where people can stay, hasn't provided information about where people can camp. It's really the combination of the time and place restrictions and the uncertainty around when someone is in a campsite that makes this objectively unreasonable. And I won't repeat what I've said about all of that, but for most people, Herring concludes, Professor Herring goes through each of these components, says that the place restrictions are objectively unreasonable, the time restrictions are objectively unreasonable, manner restrictions, he does say, is somewhat objectively unreasonable, and the penalties are objectively unreasonable. But it's the combination of those at this stage that are just collectively so objectively unreasonable. Again, we're just at the beginning of this case, but at this point we meet the standards for a preliminary injunction, and that is, we've shown that we're likely to succeed on the merits of both of our claims, if that's the test. We've shown that it appears that we're entitled to relief under ORCP 79. We've shown, and the city hasn't really refuted, that people are going to be harmed, and that the harm that is described is irreparable in many cases, in the biggest possible sense. Balancing of the harms, again, I won't go through it, but it tilts heavily in plaintiff's favor, especially because of the temporary nature of a preliminary injunction. And so we ask that this court preserve the status quo and join the city from enforcing this ordinance until there's a final judgment on whether it is objectively reasonable with regard to people experiencing homelessness, and until there's a final judgment as to whether the penalties violate Article 1, Section 16 of the Oregon Constitution.
Thank you. Ms. Sheffield.
Thank you, Your Honor. I think Plaintiffs' Counsel started and raised, again, the point that I think we've all talked about is that these are difficult issues, and these are uncomfortable decisions because they affect people's lives. People who are already experiencing difficult situations will be subject to regulations under the city's ordinance, or are currently, but would be potentially have enforcement taken against them. But those questions and those big issues, while they're uncomfortable, it's not, the answer isn't to address whether or not, kind of how any individual person feels about that. It's to ask what the legislature did in 195-530 and what they decided that the city was allowed or not allowed to do. And the legislature specifically allowed the city to put in place time, place, and manner regulations, as long as they were objectively reasonable as regard to the time, place, and manner with respect to regard to individuals experiencing homelessness. And they specifically looked to the decisions in Blake v. Grants Pass and Martin v. Boise. And what the city did is consistent with what the legislature asked and what those courts said. And it's not the place of either the court, it's not the place of the court to substitute in Professor Herring's judgment for that of city councils or plaintiff's judgment, or even its own judgment about what the best way to solve the particular challenges are. It's only to ask whether what the city chose to do was preempted by the legislature, whether the ordinance cannot exist without conflicting with 195-530. And the answer to that is no. The ordinance can be read consistent with 195-530, and it's consistent with both the text and the legislative intent that was indicated clearly by the legislature. Plaintiffs have suggested that enforcement will exceed what the plain language and the city's expressed understanding of the ordinance reads. And if at any point that were to happen, the plaintiffs could come back to court if that were to be the case. But the plain language of the ordinance, as written, as challenged, is not prohibited by 195-530. And again, plaintiffs counsel acknowledges they don't know how it will be enforced. And but that's not the question. The question is whether facially there's a prohibition of 14A 50020 by ORS 195-530. And finally, with regard to, again, the irreparable harm that plaintiffs identify is largely on the assumption that they are not or will not comply with the ordinance. But that evidence doesn't exist. Plaintiffs have, again, largely indicated they appear to be complying. There is space to comply. There are times that you can comply, and it is possible to comply. It does not prohibit sitting, sleeping, lying under a blanket. So I do not think that plaintiffs have demonstrated that they will be irreparably harmed during the enforcement of the ordinance, or during enforcement of the ordinance as this litigation continues. And with respect to the status quo isn't working. And that's what the city of Portland has realized, and that's what cities all over the country are realizing. The status quo is not addressing the problem. And the city is not under any illusion that this ordinance alone will solve the problem of homelessness, but the city does need the tools that are available to it to continue to address the very significant issues that it faces. Thank you.
Any rebuttal?
I mean, I can't pass up the opportunity to have the last word, and this is not, I'm not going to go through it all, but because I am still litigating the Grants Pass case, I just have to point out my perspective and our view, which is that 195-530 didn't codify the holding of Grants Pass and Boise. The holdings of those cases, because of the facts in both of those cases, is that you can't make it illegal to engage in survival activity everywhere in a city with at all times when people have nowhere else to go. Grants Pass doesn't have a single shelter bed. The facts in those cases just said, there was a judge with facts in front of him, and he found that violated the Eighth Amendment, both excessive fines and cruel and unusual punishment. But the fact that those cases prompted the Oregon legislature to draft a different ordinance does not mean that holding is what ended up in ORS 195-530. And if you look at my colleague Becky Strauss would give me trouble if I didn't point out that there are many other parts of her testimony that are included, again, in Ms. Sheffield's declaration, where she points out that what they were doing was building on. In fact, Commissioner Dan Ryan's testimony was building on those cases and creating a new rule for Oregon. There's nothing in Boise or Grants Pass that says you must consider the impact on people experiencing homelessness. That is a result of those cases. It was a foundation for House Bill 3115, but it isn't the test that's in front of this court. And in fact, there's nothing in those cases that would tell the court whether a time, place, and manner restriction is objectively reasonable or unreasonable. The courts just say the city could probably come up with some places and some times where people are not allowed to camp and pass constitutional muster. That's also in footnote 8, I think, and then the Grants Pass court says that true too, but it doesn't answer the questions before this court. And 195-530 is not just simply a codification.
Thank you all. Thank you for well-written materials and your professionalism this morning. as I said, I will endeavor my best to get a decision by the end of the day, and if not, before Monday morning. And again, thank you.
Thank you, Your Honor.
And we are off the record.